We're gonna hit.
All right. Hello, everybody. I'm Athrea Mathur, the Director of Legal Research at the Center for Art Law, and I'm so excited to welcome you to our event, Market and Rules for Italian Cultural Heritage, From Art to Fashion. Before I introduce our wonderful speakers for today, and as per usual, let me let you know a little bit about the Center for Art Law and what we do. We are a Brooklyn-based research and education nonprofit, and we're dedicated to offering resources and programming to advance the arts and law community. Through our website, our newsletter, events, we disseminate information and we try to keep our audience updated on everything art law, programs, publications, movies, cases, and a lot more. We also facilitate tons of conversations by hosting and participating in programs such as today. And of course, this doesn't even begin to describe everything that we do. So we invite you to subscribe to our newsletter if you haven't already to receive updates. You can also consider becoming a premium member to receive offers and discounts for events and access to our case law corner, articles, and recordings of our past events too. We have a workshop on copyright licensing coming up in March. And we're also very excited to announce our 2023 Art Law Conference at NYU in April, which will also be virtual this year. These will be up on our website soon, and you can register for hopefully all of them so that we can see more of you. A few of the usual housekeeping items. The program is being recorded for archival purposes, but we'd love to see you, as I've mentioned, so please feel free to keep your cameras on, but your microphones muted for the time being. Once the video is available, we'll send across a recording of the session, the material and handouts for the event, as well as a survey. And if you have any questions for our speakers, we'll have a question and answer session, so please put them in the chat box. Now, coming to our topic for today. Our speakers will help us understand the many facets of Italian cultural heritage regulation and what legal rules may be relevant as Americans purchase 21st century art and fashion. Felicia, one of our speakers for today, is a comparative cultural heritage art and fashion law scholar and the founder of Fashion by Felicia. As part of her academic activities and projects, she collaborates with brands and cultural institutions on design and heritage initiatives. Our second speaker for today is Anna, who's an adjunct professor of art market legislation, and she advises public and private institutions on cultural heritage law, policy, and art law. She's focused her analysis on the legal protection of contemporary art, artist contracts, and so much more. As you can probably tell, I've only touched very briefly on the many, many things that our speakers have done. So you can read their full bios in the handouts for today, which will be sent across shortly. And for now, and without any further ado, I will hand it over to Felicia and Anna. Thank you so much once again for speaking with us today.
Thank you so much, Atreya. We are so enthused to be here. And I think as Anna said earlier, it's been a long time since we've watched the Center for Art Law's initiatives and events, and we're just so thrilled to be a part of them now. And thank you, Atreya, for all your organizational help, and to other members of the Center for Art Law who are with us today too, helping with the organization. So I'll get us started. As Atreya mentioned, we're going to talk about Italian cultural heritage law today, but we're going to talk about it mainly from cultural property a standpoint, but also we'll delve into art and fashion, which are, if you will, on the frontiers of cultural heritage in Italy. Everyone can see my screen? Yes? Okay, great. So first, a little bit about what Anna and I work on together. We're also guest scholars at IMT School for Advanced Studies in Lucca, and we've co-founded a research network, Law and Cultural Heritage Across the Atlantic. Mainly, it's very much based in the conversations we had as PhD students together. We often found ourselves comparing intuitively the rules in the United States and the rules in Italy. So I've put up here on the slide just two quotes that often inspire our work. how the dramatic differences between Italy and the United States, the American style often become less so when placed in context. And that's very much what we try to do. We recognize that the notion of cultural heritage is actually more nuanced than it might first appear to an American audience, and that while the United States, for example, might seem comparatively less protectionist than Italy, we certainly have cultural heritage that is important to us, which we'll talk about a little today as well from a comparative standpoint. And we certainly also recognize Italian cultural property within our borders. And also there's this quote that we've put up here in Italian, just to say that Italy and Italian scholars have also looked to the United States and recognized certain nuances to the United States cultural property regime, including, for example, how the United States might not at first have some of the great works of cultural property on its own territory, but has other things like archaeological objects. And so over time has regulated those. So certainly more to say and more to nuance in this space. And that's what Anna and I do together. So what might be some of the biggest misconceptions that we have when we think of Italy from an American perspective, and even vice versa, the United States from an Italian perspective? Well, Italy might seem rather protectionist, and America might seem to have a disregard for cultural heritage comparatively. We need only think about, the conversations about removing monuments and keeping monuments in Italy as one point for this. Italy might seem to have a comparatively greater respect for the author if we think of the strength of moral rights in Italy and how they're perpetual, versus in the United States, we might think we defer more to economic rights and copyright and carve out moral rights for authors only in specific circumstances for certain subject matter. We might see America as having a great free art market principles compared to Italy, where the circulation of artworks is restricted, although we'll talk today a little bit about how now, of course, in the United States, we've put restrictions on the circulation of Native American objects. And so, again, nuancing some of the preconceived notions and misconceptions. And then, of course, perhaps there's a vast American public domain, and Italy encroaches on the public domain, taking things out of what we can use in digital works, for example, and other artworks in order to regulate them and the cultural interest in them. So are those misconceptions really accurate, or can we nuance them more? So on that note, I'll turn it over to my colleague Anna to talk a little bit more about artwork versus cultural property in Italy specifically.
Thank you very much, Felicia. Hello, everybody, and thank you very much to the Center of Art Law for having here today with you. We are very happy. So in order to start analyzing this misconception that we could probably see, or we could probably have between the differences of Italian and American protection of cultural heritage and artworks, we just wanted to start our discussion with you today by underlining how in Italy we have a strictly different regulation that protects artworks and cultural property. And what is interesting, according to me and Felicia, is to put into relation these two different kind of regulatory frameworks. So of course, when we talk about art law, and so we talk about the protection of artwork, we are in the domain of private law, commercial law, and so we deal with issues regarding the legal definition of artworks, contracts for their circulation, commission, sale, etc. And so the actors that we are dealing with mostly are artists, collectors, art galleries, and also the legal principles that are taken into consideration for both the acknowledgements and the protection of artworks are different from those taken into consideration for cultural property. So for example, when we deal with the protection of artwork, and so with copyright principle, we respect what we call the principle of aesthetic neutrality. Copyright law in Italy, as many other copyright regulations, do not state what is art, but just define criteria that needs to be respected or encountered in order to be to possibly define by a legal point of view an artwork. When we talk about cultural property, we enter in a different kind of regulation. So we are in the domain of public law and administrative law, and so also the actors involved are different. We have mostly public actors or state, public museum, regions, and also private actors as individual, as the owner of cultural property, as we will see. In terms of the legal prerequisites that we take into consideration when we talk about cultural property, those are the so-called cultural values. And so, as we will see, we will talk about artistic interest, historical interest, archaeological interest, etc. So it is important to have in mind this differentiation, because the applicable law, the actors involved, and the legal prerequisites among the protection and acknowledgement of artworks and cultural property are very much different. In terms, if we can go to the next slide, please. In terms of the origin of the protection of cultural property in Italy, just to give you a very brief background that is much needed, not because of the specific rules and of the specific enactment of legislation, but it is important, this historical background, just to understand that when we talk about cultural heritage legislation in Italy, we talk about a legislation which exists since many centuries. The very first rules regulating the protection of cultural property and cultural heritage exist since the 15th century, and they exist even before Italy exists as a unitary state. So we have a number of papal bulls, for example, that were made because, of course, the State of the Vatican were very rich in artistic collection, paintings, sculptures, etc. And these papal bulls were meant to forbidden the export or the destruction, for example, of this very artistic collection outside churches or outside the borders of Vatican states. Italy was unified as a kingdom in 1861 and then completed the unification in 1871. But the Unitarian Kingdom of Italy didn't enact a Unitarian legislation on the protection of cultural heritage until 1902. So 1902 is the first year in which we have a first national Italian law recognizing the importance of cultural heritage. What is very important to say is that the national Italian law on the protection of cultural heritage really has its basis and takes its core principles by the pre-unitary legislation. So all the pre-unitary legislation that we had since the 18th-19th century, that we have in all these legislation enacted in the Vatican states, were adopted also by the unitary Kingdom of Italy. Something very interesting to quote, for example, by these pre-unitary states are the reasons why, for example, the Cardinale Pacca Edicts was enacted, and the reasons why are that the Vatican state recognized that artworks and artistic collection were the very wealth of the city of Rome, and because of that, and because of it was important to maintain the possibility that foreigners came to Vatican states and to admire these beautiful masterpieces. They needed to be protected. So this very reason, these very basic reasons for the enactment of such kind of regulation are found also in the legislation of 1902, for example, and 1909, in which, of course, there are more specific details, for example, regarding the object of the protection. Another important legislation that we can quote is the legislation of 1939 that was enacted during the fascist period. This legislation has inspired the legislation of all the 20th century that we had in Italy, and contains some of the major elements that we still have today in the Italian Code of Cultural Heritage Landscape. So arriving to contemporaneity, if we can go to the next slide, in order to conclude this very brief historical background. Of course, you will have the slides, you will be able to go through the legislation, you can ask us more specific details, but just to conclude this very brief historical background, let's see what the Code for Cultural Heritage and Landscape that was enacted in Italy in 2004 states. So as a very, very preliminary indication, we have to say that in Italy, cultural heritage comprehends not only cultural property, so tangible cultural heritage, but also intangible cultural heritage and landscape. So landscape, intangible cultural heritage, and tangible cultural heritage are the main facets that contradistinguish Italian cultural heritage. When we talk about cultural property, so tangible cultural heritage that can be both movable and immovable, of course, we have to take into consideration some very basic elements. The very first important element is that a cultural property can be both in public hand and in private hands. So the ownership is not indicative of the possibility of being considered a cultural property. Another very important element is that cultural property are identified according to a time and an economic threshold. So the very same artwork can, with the passage of time, can become a cultural property. Of course, it can become a cultural property also if some subjective criteria are recognized, such as I was saying before, historic, artistic interest, archaeological interest, etc. What is very important to state, and here I will finish with this slide, is that every cultural property, even if we are talking about a tangible element, a tangible good, it is a cultural property because of also of its immaterial element. So the immaterial element that contradistinguishes a cultural property is its cultural value. So when we think about a cultural property in Italy, we have to take into consideration, of course, the embodiment, the object, the tangibility of the object, but also its immaterial element, which is its cultural value. So I will leave the floor to Felicia now.
Thank you so much, Anna. So on this note, we get to really the comparative element. So at first, when you heard Anna detail Article 10 and time, time thresholds and tangibility, you might think, well, doesn't seem like we have something that's similar in the US. But in reality, if you think of all the different laws that we have in the US that help us to recognize certain aspects of our heritage, you see that, in fact, we might have greater commonalities than we at first think. So whereas it's true that in the United States, we are hard-pressed to recognize a Van Gogh painting when it's outside of a museum, like Italy can recognize that same Van Gogh painting for artistic interest as cultural property. The famous example, of course, is that, if you buy Da Vinci at auction in New York and you want to set it on fire and there are no conditions attached to the property, in an ideal world are able to do that. But of course, in Italy, you could never do that. But on the other hand, if we think about immovable property, think, for example, of Macy's in New York, think of the Statue of Liberty. Think also of, other places that are of interest to us. We see that the National Historic Preservation Act actually has significance in it. It also has, some time thresholds as well, and also integrity. So you do have ways in the United States to recognize, similar to Italy, what is of cultural interest to us in the United States. At the same time, at the local level and perhaps at the state level, you have regulations or controls that are perhaps more similar to Italy. So remember, in New York, for example, if you own a property that's a landmark, you have to apply for a certificate of appropriateness to change something in the front of the building. At the federal level in the United States, that's generally not something that is required, meaning, there's not a check on changes to the property unless perhaps your property is part of a historic district. So there's a little more freedom there, but still there are these similarities in recognition of historic interest and of how we decide what that historic interest actually is. Think, for example, of how on federal lands in the United States and in public lands, we do recognize that archaeological resources belong to the federal government. We certainly recognize that Native American communities have a right to have their sacred objects and objects of their cultural patrimony repatriated to their communities, that they have a right to have control over those objects, much as the Italian community recognizes that the Italian state steps in for members of the Italian community in order to manage their own cultural heritage. I mentioned before, President Biden recently signed the STOP Act that will regulate the exportation of Native American sacred objects. There's a distinction between sacred art sacred objects for the Native American communities and art. Again, something similar in Italy that, we'll talk about religious interest or other interests versus artistic interest. On the one hand, of course, in Italy, you can't deaccession from museums like you can in the United States. But Italy has recently recognized the institution of a museum, much like we historically in the United States have recognized that non-for-profits have their own statute and have their own obligations in managing the works that are part of their collection. So there's some similarity there. Certainly, we provide in the United States a great deal of tax incentives in order to found your own museum or restore a property. And there are certainly comparisons there with Italy, the Art Bonus initiative and other more recent implementations that allow private individuals to donate to cultural initiatives. And of course, the United States recognizes, for example, Italy's cultural property and will bring claims under the National Stolen Property Act, or of course will stop the illegal export and import of objects into the United States as well. So a way to, shall we say, nuance those misconceptions that we had first identified at the top of our presentation. Anna, back to you.
Yeah. So we will focus a little bit now on art export control. So what are we talking about? We are talking about the possibility for the state to deny the possibility for a private individual, for a private owner, to export on a permanent basis an artwork in his or her possession because of a national cultural interest. Just to say why we are looking at art export controls and why it is important to focus on this very specific function of cultural heritage legislation. The reasons are mainly two. The first one is because of an historical reason. Art export controls were the first kind of public control on cultural property that were enacted, as we were saying before, in pre-unitary states since 15th century. So for one side, art export controls has an historic importance. But secondly, they are important because shed a light on some of the major clashes that we have, clashes of interest that we have in cultural heritage legislation, as we see the opposition between private and public actors, economic and cultural interest, and also a feeling of nationalism and internationalism. In Italy, art export controls, this very administrative function, is based on the belief that the retention of artworks is aimed and is needed in order to constitute the domestic cultural heritage. And of course, this very theoretical thought has two major consequences, because from one side, art export controls are implemented in order to build and to feel a sense of national belonging, but from the other side, we should also take into consideration the economic consequences that derive from the possible retention of artworks belonging to private individuals. So just to quote, some economic studies have demonstrated how the economic value of an artwork who has been denied to be exported on a permanent basis lost the 40% of its economic value. So we should also take into consideration the dichotomy between national interest and economic interest of the private individual. If we can go to the next slide, I just would like to introduce this topic, which I won't discuss in details regarding the procedures, but just introducing this topic by saying that in art export controls, economic value matter and times matter. What does it mean? It means that only certain artworks are subjected to these public controls when they want to be exported. And what are these artworks? Are those artworks that have been produced for more than 70 years and from the date in which the owner would like to export them, and which have an economic value that is more than 13,500 euro. I just wanted to give you this example of these three beautiful artworks by Alberto Burri, an Italian artist belonging to the movement of Arte Povera, because we are dealing with artworks that are made from the very same artist, but which have a different date of production. And the date of production really determine whether these artworks are subject or not to a possible ban on their export. And so if we can go to the next slide, just again, I won't go in details into the procedures, but I really would like to let you know that when we talk about a possible export of an artwork from Italy to the United States, we have to know some basic rules. First of all, artworks cannot be exported on a permanent basis if these artworks are already considered to be a cultural property. So if these artworks have already been notified. All those artworks which are not considered to be, by a legal point of view, a cultural property can be exported, but the owner should ask for a certification that according to the year in which the artwork has been produced, changed. So we should ask, for example, an export license plus a self-declaration of contemporary art for those artworks which have been produced by more than 50 years. And we should ask an export license plus a certificate of free circulation for those artworks that were produced by more than 70 years. Something important to know is that artworks that have been produced in the last 50 years from the date in which the export would like to happen are not subject to this public control. Another important element to consider is that when I would like to export an artwork from Italy to the United States, I should apply not only Italian regulation, but also, of course, European regulation, because Italy is subject also to the communitarian regulation. If we can go to the next slide, I will make a brief example with a case study. So we have here the situation in which a private owner in 2018 wanted to export this artwork that is a testa di Medusa, head of Medusa, that is like a piece as the one that is held in the Uffizi gallery. So we have this owner of this painting, of this artwork, who already entered into a contractual relation with a US bank, and in order to finalize this sale had to obtain an export license by the administrative Italian authority. The export license was denied because the piece was found to be exceptionally important for the national cultural heritage, not because of only of its beauty or its artistic importance, but because from also an historical point of view, it was considered fundamental for the study of Caravaggio's execution technique. So this is just an example to let you understand that the reason why the Italian states could deny the possibility to export an artwork could be differentiated. What is interesting of this case is that when the owner appealed the denial that he received by the Italian administration, he appealed by saying that the very existence of art export controls were not fair for private individuals. And the owner said that the private ownership, the right of ownership, of private ownership was diminished for a general interest of the Italian states, but this general interest didn't have reason to exist because of two reasons. First of all, because the international circulation of artworks was beneficial for the valorization of the piece, and also because thanks to the digitalization nowadays, even if the piece was not in the Italian territory anymore, could have been enjoyed by Italian community and by everybody. So in the next slide, we can really see some of the reasons underpinning this administrative function. So what is very crucial here is to look at this dual nature of artworks, because from one side we are dealing with something that of course are objects of trade. Artworks are sold, are exchanged in the international art market, but at the same time they are also recognized as very important for the preservation of the national identity. And so, for example, we can also see that some international rules of trades are not applicable to artworks. So in Italy, art export controls are founded on the idea that the retention of artworks in the Italian soil is important in order to maintain a link with the past, and so to really create and enforce the establishment of a nation state, and also on the belief that in some situations, some circumstances, it's only the state, the public authority, which can make this judgment regarding the appropriateness or not to enjoy the property, the private property in some ways. So these are really the pillar on which in Italy we base this crucial administrative function.
Yes, and so on that note, Anna has raised in her parts of the presentation the dichotomy, of course, of internationalism versus nationalism that we talk about a great deal in cultural heritage, and this specter of the export license. I mean, if some of you were thinking about the Caravaggio example, it might seem as though, well, how does the Italian state decide that this is of exceptional cultural interest? What are the boundaries? And of course, this brings up the issue of, well, why should Italian cultural property law particularly matter in the US? Of course, many of us on this call are probably familiar with the case of Marion True, a former curator of the Getty who was effectively brought up on criminal charges in Italy for what was said to be her role in acquiring looted works for the Getty's collection. That's an example of how, because of the broadness of Italian cultural property law, which as a vesting ownership statute includes the export license that Anna mentioned, but also especially now after the implementation of the Council of Europe's Convention on Offenses Relating to Cultural Property, reiterates this commitment to punishing crimes against cultural property, but in also this very justification of preserving cultural property for the community, of also, communicating its cultural interest. We can see that it's of interest to museum curators and to us as members of the American public for, a practical reason, we might say. None of us want to be prosecuted in Italy, but, at the same time, on the other hand, many of these laws in Italy can be criticized by a US audience because of their broad scope. I mean, Marion True's case, for example, actually was halted because the statute of limitations in Italy, prescrizione, which actually refers to the time in which a case needs to be completed or finished, whereas in the United States, we usually think of the statute of limitations as circumscribing by when a case can actually be brought, expired. So, many American curators, and in fact, Marion True herself said, well, this was just basically a shakedown, right, of the Getty and the collection. And, some critiques still happen from the American perspective if we think of current cases like the Victorious Youth, which is still in the collection of the Getty. Some of you may have heard of this statue. It was discovered in the waters off of Italy by Italian fishermen. That's been a part of the case that's being litigated in Italy right now. Does this does this object actually belong to Italy? Where does it matter that the fishermen were Italian, that the Italian ship was flying the flag? The Italian courts seem to say yes, but they also say that because this object entered Italy, even though it historically was from Magna Grecia, the object belongs to Italy. And so, this has also been cast as constructive ownership, if you will. But, recalling what Anna noted about the cultural property box, Italianness is not only what defines cultural property in Italy, it can be a broad artistic interest. In fact, American collectors have donated objects to the Italian state and their collections have been notified. It doesn't matter that they're American. And so it's important to think about these, nuanced aspects of the definition of cultural property and what's animating Italy's actions here beyond simple, misconceptions or easy dichotomies. And so I would just mention, of course, why does it matter? Well, criminal actions in Italy or possibly in the US under the National Stolen Property Act, as I mentioned, the export controls that Anna spoke about are within the code and so might be thought about as vesting statutes and not just as export licenses. Of course, we always have the application of the Cultural Property Implementation Act in the United States. There's always, of course, the fear of extra legal naming and shaming, and leverage over management of your own cultural heritage work. I mean, we're seeing this with the Getty right now, and the way in which Italy is framing loans to the Getty in light of the victorious youth and other artifacts that are in the collection. So things that I would mention on a last note too, I would also say that there are some exceptions in Italian law as to when an object that's found in a museum or in another collection can be confiscated. We see this happening in the victorious youth case now. The parties that are extraneous to the theft, if you will, are under the law seen as not liable or not, the work can be confiscated from them. But in this case, the Italian courts have read not extraneous very broadly, if you will, and have said that because the Getty didn't notice some red flags in their purchase of it, because the Getty is still deriving a material benefit from having the object in their collection, that this makes them in fact a party to the original taking of the victorious youth. So, perhaps if you're a museum curator on the call or, someone else interested in this area, another reason to follow ethical guidelines in order to really be seen as recognizing the provenance and the red flags and the place of this object in Italy's cultural heritage. Another thing is, as part of the case, and the last thing I'll say is that the court also drew a difference between the role of experts in U.S. courts and the way in which an Italian judge will evaluate the purchase of an art object and a cultural property. So also things to keep in mind as to how Italian courts also view American law there. So after those two cases, we see obviously that in the United States, we do repatriate a number of cultural property objects to Italy. And of course, as Anna has said, there are very good reasons that found these repatriations. But it's also in here, I've put up an image of the new, Museo dell'Arte Salvata in Rome, as well as the Euphonius crater in the Villa Giulia that was returned from the Metropolitan Museum of Art. But of course, as Spider-Man, with great, power comes great responsibility. With repatriation comes responsibility. And so it's important to remember that even in Italy, a country that we might even call, and others have called, an open air museum with all of its cultural property requires preservation, but also valorization. And that's a term of art in Italian cultural property law that means enhancement, that means communication of the cultural interest in the cultural property. And so how is Italy to do that responsibly, and how are we to participate in that when in fact there are so many things and there's so much to learn? At times, the Italian state has, even been deemed in Italy as perhaps operating at the limits of what this regulation of the preservation and supporting of valorization means. So Anna, I'll turn it over to you to delve into the right to an image of a cultural property and more of the, if we might say, copyright cultural property interface.
Yeah, thank you very much. So we will deal now with another very important area of Italian cultural heritage legislation. So we were dealing with art export controls because of their historical importance and because of the clashes that this very administrative function brings to light, but also the possibility of reproducing cultural property according to Italian cultural heritage legislation is very relevant. So we are going to analyze here, briefly analyze, unfortunately, a case which saw the Italian Ministry of Culture against Brioni Spa, which is an industry in the fashion industry. What was the case? The case is that this industry, Brioni Spa, SPA, used the image of David of Michelangelo, the very famous Renaissance sculpture, which is in the Galleria dell'Accademia in Florence. The statue was used in order to shoot a video for the campaign Bespoke, in which the David was wearing a suit, as you can see on the left, of Brioni Spa. When the Italian Ministry of Culture knew about this advertisement, who was circulating on internet, in shops internationally, etc., etc., when the Italian Ministry of Culture found out about this, of course, started a trial against this enterprise. What are the legal basis of this trial? We have to take into consideration two articles of the Italian Code for Cultural Heritage and Landscape. These are articles 107 and 108, according to which the reproduction of cultural property, so these artworks which are in public domain or and which are in the permanent collection of museums, as David is. So the reproduction of cultural property needs an authorization by the competent institution, so by the museum, for example, which is hosting the artwork, and not only need a prior authorization, but also it has to be paid a fee for the commercial use of this image. So this is the legal basis, and why it is important, this trial, because in this trial the Tribunal of Florence, while deciding whether Brioni Spa SPA was liable or not, really enlarged the concept of use, of fruition of a cultural property. According to the Tribunal of Florence, who delivered this ordinance last year on April 2022, the fruition of a cultural property happens also thanks to the reproduction of its image. This means that also the reproduction of the image of a cultural property needs to be protected as we protect the cultural property itself, the object itself. And this is a very innovative sentence, if we can say in this way, because it really establishes what it is the right to image of cultural property in Italy. And if we can go to the next slide, I would like to make this very brief reasonment with you by trying to underline what are the limits of this protection that we have in Italy regarding the reproduction of cultural property. So first of all, I would say that we have a temporal limit. So we should reflect how this public regulation on the possibility of reproducing artworks goes in line with copyright law. We know, of course, that economic rights expires after 70 years, the death of the author. Here we have an example that for this kind of property, the reproduction never falls into public domain. So temporal limit. An extraterritorial limit also, because we have to take into consideration that Italian regulation only applies on Italian soil. Italian regulation on cultural heritage. So, of course, we could not deny an American institution, for example, for using, even for commercial purpose, an Italian cultural property. And this is the case, for example, of what happened in 2014 when Armalite made this advertisement by reproducing the David of Donatello and calling the gun that was advertised a work of art. In this case, the Italian state didn't have a lot of possibilities to deny this reproduction, but the moral suasion. So only moral suasion, and as Felicia was saying before, naming and shaming could help Italian institutions to deny the non-authorized commercial use of cultural property. And so here we arrive to the final limit, so a functional limit. So maybe we should reflect more on the needs to balance the willingness to protect and valorize cultural property, because we could arrive to the paradox that Italian cultural property could be reproduced only abroad and not in Italy, because in Italy it is not permitted. So
Yes, and just as Anna's saying, I mean, you know, in the United States, we might see this as an encroachment on the public domain, but also a type of, you know, trademark right, if you will. I mean, if you look at the Armalite advertisement, if you study trademark law or practice in the trademark space, you might say, well, this sounds like a tarnishment claim that the Italian state is trying to bring. And in fact, you know, it raises questions also even in the Italian communities about how Italy, the Italian state, might in fact be regulating the development of cultural interest too, and might, you know, be frustrating, if you will, both the evolution of Italian cultural heritage, but also engaging in what I call an Italian style of cultural appropriation. So really mediating how images of cultural property are used by Italian communities themselves. And of course, this can have positive aspects, you know, as Anna showed with the image of the David with a rifle. I mean, I think notwithstanding David and Goliath comparisons, you know, we might look at that and immediately say, oh, that seems very inappropriate to us. But on the other hand, you know, the workshop from whom Brioni actually took the life-size copy of the David was a workshop in Carrara that engages in marble carving and the making of marble sculptures that is in fact part of a wider Italian cultural heritage. So in halting that company from using an image of the David or producing a reproduction of it for commercial purposes, in fact, you know, the Italian state in some ways is infringing on the very activities of a workshop that continues Italian cultural heritage. Similarly, many fashion companies have a close link between their brand identity and the artisanship and the craftsmanship and the made in Italy products for which Italy is known for. So, you know, what are we to do with that when an Italian company in fact represents communities in Italy very well? And, you know, this brings us to the question of fashion's role in the Italian cultural heritage space and how fashion companies also, on the one hand, can promote Italian cultural heritage. We see this, for example, in endeavors like Fendi's Hand in Hand series, where they asked local Italian artisans in each region to reinterpret the iconic Fendi baguette. And also, you know, I see we have a question in the chat about UNESCO's role. Here you see an Italian fashion brand building on the UNESCO program of Living Human Treasures to market a product that has therefore both Italian cultural heritage elements and fashion elements. So there is something that can be said for Italian brands acting, if you will, in a gray area of Italian cultural property law. Now, can fashion itself be cultural property under Italian law? Well, you know, the legal answer, the quintessential legal answer is it depends. It really depends on, you know, the facets of Article 10 that Anna called out earlier. You know, remember that fashion, depending on how, you know, when it was created, is recent, and individual objects, usually under Italian cultural property law, need to be over a certain age and by a non-living author. So how do we define author, especially if we think of a brand as defining a fashion product? Certainly, fashion objects that are already in collections of public museums, like the Museum of Fashion and Costume in Florence, are indeed part of the cultural property box. They're presumed to be cultural property. But, you know, at the same time, how do we parse what actually is of cultural interest to us in a fashion object? Is it the intangible fashion design that is reproduced on a number of different products? Is it the fact that one dress was worn by one person or designed by one person? So we see that this is a frontier of Italian cultural heritage law. And of course, a frontier in which many fashion brands in Italy are participating very well. There are examples like Ferragamo is perhaps the best archetype, which preserves its historic collection of shoes designed by Salvatore Ferragamo and its prototypes in an archive that has been, that is cultural property under Italian law because it's owned by the Ferragamo Foundation. At the same time, it also uses intangible parts of these historic shoes, like the invisible sandal, which also has a design patent, or had a design patent rather, and the F heel, to create new fashion products. So this brings up how we talk about everyday products. Some authors have called these cultural products, for example, and how we put them into the cultural property box or regulate them if we should. The word iconic now, for example, is thrown around a lot in marketing campaigns. Actually in Italian copyright law, fashion objects inclusion in a museum collection and referring to it as iconic might allow it to be to have a copyright in the design, because industrial designs that are of creative character and artistic value are recognized under Italian copyright, as opposed to in the US. So just a question, for us to talk about. And this brings us just to the last part of our presentation, where I know Anna might just give us some macro takeaways for artwork.
Yeah, we could directly go, we could skip this part so we can go, yeah, just like you will have the slide. So these were just like questions that we wanted to leave you as to reflect on some takeaways. And if we can go further, we can just say, these are those topics that we covered are of course we briefly covered these kind of topics, but as Felicia was saying at the beginning, if you can go to the next slide, as she was saying at the beginning, we started this project since 1 year, this academic network regarding the comparison of Italian and American regulation of cultural heritage and contemporary artworks, and we keep on doing different activities, among which a summer school that we held in Lucca in Italy in June. So if Felicia, you want to conclude, and then we have some time for the question.
Yes, absolutely. So I see we do have a lot of questions, so I'm eager to get to those. Just to say, if you enjoy our presentation today, or you have more questions, or you want to either come to Lucca in person or virtually and meet other cultural heritage professionals in Italy that delve into these questions and network, we are holding our summer school again this year in June. The focus this year is creative industries. So we'll be talking a lot about the IP cultural heritage interface and heritage brands in Italy too. I've put up a picture here of Martinelli Luce, which makes historic designs, lamp designs, and of course the Ferragamo Museum. And so grazie to all of you. And if you would like to email us, that's our email, visit our website. And I think it's time now for questions, Atreya, because we've got some great ones in the chat. So I'll stop sharing.
Thank you so much, Felicia and Anna. This was a terrific presentation, so much information, and I'm glad that we have access to the PowerPoint, because I think there's just a lot to kind of mine from there as well. So thank you once again for taking the time out and telling us everything that we may want to know about Italian cultural heritage, property, art, the differences, and a good comparison between Italy and the US. So before I go on, thanking you once again, I will move to the questions. You had briefly mentioned UNESCO, but do you think you could elaborate a little bit more about the role that they might play in the laws and the regulations to protect World Heritage sites that are of cultural significance?
Absolutely. So Anna, if you want, I can start and then I'll turn it over.
Yeah, I think I can take the last ones that are more Italian tailored if you want. So
great. So I will just say, yes, that's a great question. So let's remember that, the World Heritage Convention recognizes certain sites that are of outstanding universal value. And what happens is that those sites are proposed by individual states. So Italy has a very robust way of reviewing, which sites are susceptible to be of outstanding universal value, and they propose them. I will also say, a great example of this is Venice, which is probably on everyone's minds, because another aspect of the World Heritage Convention is, of course, also the World Heritage in Danger list and the Red List. And so most recently, you might have heard a couple of years ago that Italy at the federal level passed a law in order to stop cruise ships from going through the Venice Lagoon, and had some discussions with the municipality of Venice, because of course cruise ships bring a lot of money into Venice. And so in answer to the question of how does UNESCO operate with World Heritage sites, I would say that remember that the World Heritage Convention essentially gives you a list per country of sites that are of outstanding universal value. And then it is the responsibility of Italy to manage that and to make sure that it stays on the list. And so there are a number of mechanisms, both at, in the United States, we would say at the federal, or in Italy, the state level, as well as the regional and local level, to facilitate that and make that happen. And Venice is a great case study for that. I hope that answers your question. Happy to talk more offline too.
Thank you so much. Another question we have is, do the intellectual property protections affect tourism or the souvenir industry in Italy?
So the answer to that is yes. So when you see these scandalous images of a David on an apron as you walk around Florence, or of the birth of Venus, those are technically illegal under Italian cultural property law. It's really a question of enforcement. And, just as we talk about counterfeits in fashion law and how difficult it is to enforce, as different counterfeits pop up on the internet. So, if you talk to the director of the Galleria dell'Accademia, she's up in arms about, these kiosks, but, they choose in many ways to go after others that are more visible, but certainly commercial uses that are not authorized. So if those kiosks are authorized, that's great and that's legal. But if they're not, and it's for commercial purposes, then yes. So get your Birth of Venus and David aprons while you can, is my point. I bought some bags, I have to say, just for the archive. So yes, that's the answer to that question. And also, they're not IP protections. I want to emphasize that. They're cultural property protections. These images are in a public domain of copyright. And in fact, if you add other things to the image, you could also have your own copyright. So, think of what Duchamp did to the Mona Lisa with the mustache. I mean, that then it becomes a real layered question of, okay, you have to ask the museum to reproduce the image of the cultural property, but if you add something, you're an artist, you have to ask the artist also for permissions for the edition. So it becomes a lot like US fair use and, US copyright licensing, but technically it's not. So I just want to make that clear.
Yeah, and just to add something very briefly, the very first case always delivered by the Tribunal of Florence, and again regarding the David of Michelangelo. So the very first case on the possibility of reproducing cultural property actually was born by the reproduction of Davids on tickets for Galleria dell'Accademia that were not authorized by the Italian ministry. So I second even more what Felisa was saying. And maybe just I can jump to the last question regarding the possibility of doing whatever the owner wants with their property if it was acquired legally. So I think that the very so the answer also here is no, but just to elaborate, It is important again to stress on the fact that in Italy, cultural property could be both in private hand and in public hand. Not only what is in public hand is considered to be a cultural property, but also private individual could have cultural property in their own possession. What does it mean? That this individual, this private owner, have on them a burden, a public burden of protection, even of fruition. The state could oblige them to make available their pieces for public fruition. And this is also, I'm glad that you mentioned, for example, the issue of destroying, because this is a huge difference that we have between cultural property and artworks. So if I was the owner of a cultural property, I have the duty and I am obliged to physically preserve it, and not only to make sure that this cultural property still exists, but to physically preserve it in its original status, so to restore it, for example, at my own expenses. If I am the owner of an artwork, so a contemporary artwork which is not considered to be a cultural property because the time threshold is not reached, for example, or because it is not considered specifically important for the Italian cultural heritage, I do not have an obligation of physical preservation of the artwork, but I have the obligation coming from copyright and especially from moral rights in preserving, for example, the honor and the reputation of the artist, but I do not have an obligation of the physical preservation of the artwork that exists only for cultural property. So yes, cultural property in private hands, even if they are acquired legally, they need to be preserved physically. Sometimes they cannot be exported, so of course there is also an economic consequence for the owner. There are all these kind of public obligation to the private owners.
Perfect. Thank you so much. And there is another question more about resources, and the center does research and provide resources, so we'll be happy to look into it, but also to post this to Felicia and Anna in case you know of any links or something that might help that addresses National Socialist looting or forced sales during World War II in Italy. So in case you have anything, I'd be happy to email you later and consolidate a list and send that across.
Sure, there is, I mean, it's a pretty, I mean, I hear it's pretty expensive, but there is a database. I'm so sorry, I'm blanking on the name, but there is I think it's the IFAR database maybe, but the IFAR database does have, some translated opinions from Italian courts, the statutes. The problem there is that when I've consulted a lot of times, I find that it's not up to date. So what I would really suggest, and many journal articles are in Italian, but many are in English. There's a art law online journal that both Anna and I have published in, that is published by Mulino, and it's Italian, and it's Eodon. And if you just put in, I put it in the chat, but it's eodon.mulino, I think .it, right, Anna? Is that right?
I will post it.
Yes, and you have a number of different articles on topics that are very, I mean, it's all Italian focused. You might have some comparative, but it's really explaining Italian law and recent Italian cases. So I would definitely recommend that. I will also say that that is part of what Anna's and my research network does. So we're an academic research network. That's what we do. So we don't give legal advice, but we're very interested in hearing from people about the resources that are missing. So we've talked to other museums in the United States and we've asked, so what's difficult for you to find or what's unclear, and they've told us, and so we're thinking seriously about how to meet that need too as part of our research network. So I think that's something we could talk about too, but just to say to any participants here on the call, if you have our email, if there's something that you feel really would be helpful, Anna and I would be really happy to hear from you.
Perfect. Thank you so much, Felicia and Anna. This was really a fantastic presentation, and I'm sure everyone here really appreciated your time, the information, and for you to stay back the couple of minutes on the hour to answer all of the questions that came in. So we really appreciate you, and we really hope to have you at center events and collaborate with you in the future. I will send across a recording of the session, the handout materials, and a link to the summer school to all of the participants as well. So thank you once again for taking the time out for this. It's been wonderful to work with you and hear your presentation.
Thank you very much to all of you for your time, for being here.
Exactly. I second Anna. Thanks to all of you. We really enjoyed this, and we hope there are more occasions to meet and talk about Italy and the US and art and cultural heritage and fashion.
Thank
Bye.
you.
Thank you.
Have a
Bye,
good day.
everyone.
Thank you. Bye, everyone.
Bye.
Okay.